Felony fraud charges in Rogers County can carry serious criminal and personal consequences. If the state charges fraud as a felony, the punishment may include prison time, probation, fines, restitution, court costs, and a permanent criminal record. Fraud cases are often document-heavy and fact-specific. They may involve contracts, bank records, checks, invoices, loan applications, insurance claims, tax records, credit card transactions, business records, emails, text messages, or accounting disputes. Because these cases can be complex, the defense must focus on the exact charge, the required legal elements, the alleged loss amount, and whether the state can prove fraudulent intent beyond a reasonable doubt. Fraud requires more than a bad result. One of the most important defenses in a felony fraud case is that a bad financial result is not automatically a crime. A failed business deal, unpaid debt, broken promise, poor investment, accounting mistake, or contract dispute does not necessarily prove fraud. The state generally must prove that the accused acted with fraudulent intent. In many cases, that means the accused knowingly used deception, false information, concealment, or misrepresentation to obtain money, property, services, or some other benefit. If the evidence shows mistake, misunderstanding, poor communication, or inability to pay rather than intentional deception, the defense may argue that the case does not belong in criminal court. Lack of intent to defraud. Lack of intent is often the central defense in felony fraud cases. A person may make a statement that later turns out to be wrong without intending to deceive anyone. A person may enter a contract with full intent to perform but later be unable to complete the work. Someone may receive money believing they had the right to it. Fraud requires proof of the required state of mind. The defense may use communications, payment history, partial performance, business records, witness testimony, and the timeline of events to show that the accused acted in good faith rather than with criminal intent. Good faith belief. Good faith can be a powerful defense. If the accused honestly believed the transaction was lawful, the information was accurate, the property belonged to them, or they had authority to act, that belief may defeat the intent required for fraud. For example, a person accused of financial misconduct may have relied on a bookkeeper, business partner, accountant, supervisor, or prior agreement. A person accused of using funds improperly may have believed the use was authorized. The question is not whether the accused made a perfect decision. The question is whether the state can prove fraudulent intent. Civil dispute versus criminal fraud. Many fraud cases begin as civil disputes. A customer may claim a contractor failed to finish work. A business partner may claim money was misused. A lender may claim financial information was inaccurate. A family member may claim property was taken unfairly. A client may claim services were not performed as expected. Not every civil dispute should become a felony prosecution. The defense may argue that the complaining witness is trying to turn a contract dispute, unpaid debt, failed investment, or business disagreement into a criminal case. Evidence of partial performance, ongoing negotiations, attempts to repay, disputed contract terms, or genuine disagreement may support that defense. Mistake or accident. Fraud allegations may arise from mistakes in paperwork, bookkeeping, deposits, withdrawals, invoices, checks, electronic transfers, tax forms, or applications. A mistake may create financial harm, but it does not automatically prove a felony. The defense may examine whether the error was accidental, whether the accused corrected or tried to correct the mistake, whether anyone else had access to the records, whether the accounting system was unreliable, and whether the alleged misstatement was material. Lack of knowledge. The state may need to prove that the accused knew certain information was false or knew they lacked authority to act. Lack of knowledge may be a defense when the accused did not know the document contained inaccurate information, did not know funds came from an improper source, did not know a card or account was unauthorized, or did not know another person was committing fraud. This defense may be especially important in cases involving multiple employees, family businesses, shared accounts, online transactions, or business partnerships where more than one person handled money or records. Mistaken identity. Some fraud cases involve online activity, electronic accounts, credit cards, checks, forged documents, or shared access to business systems. The accused may be blamed because their name appears on an account, because they had access to a device, or because they were associated with someone else who committed the act. Mistaken identity defenses may involve IP records, device access, login history, handwriting analysis, surveillance video, bank records, witness testimony, and evidence showing that another person had the opportunity or motive to commit the fraud. Constitutional violations. Fraud investigations may involve searches, seizures, interviews, subpoenas, bank records, computers, phones, business records, or statements to law enforcement. If the government violated constitutional protections, the defense may seek to suppress evidence. Possible issues may include illegal search and seizure, improper interrogation, lack of Miranda warnings when required, involuntary statements, overbroad warrants, unlawful seizure of electronic devices, or improper handling of privileged materials. Suppressing key evidence can significantly weaken the state's case. A lawyer can review the documents, financial records, witness statements, alleged loss amount, and prosecution theory to develop a defense based on the evidence.